Hello, everyone. We're going to go ahead and get started. It looks like it's 12:01. I'm Sherry Blackburn, and Mary Stewart King is with me. And we are giving what I believe is the third presentation in our webinar series. Several of you have probably signed up for the webinar series for the entire year. You can do that, or you can do a single webinar. And we hope you are enjoying these. And if you know other individuals in HR or anyone who might be interested in attending or participating in the webinar series, just please let them know. We're going to talk today about reductions in force, which would include both voluntary and involuntary reductions in force. We're going to talk about the Older Worker Benefits Protection Act and what you need to do to make sure you are complying with it. Severance agreements, how to draft them, best practices, and how to make sure you're avoiding discrimination claims when you are reducing your workforce. I'm going to cover those topics, and Mary Stewart is going to talk about the Worker Adjustment and Retraining Notification Act, which is commonly referred to as WARN. It's got some tricky provisions, and she's going to talk to you about what events trigger compliance with WARN, what the notice provisions are under WARN, and also several states have mini WARN acts, which you also need to be aware of when you're laying off employees. So let's start with reductions in force. When we started 2023, we saw really at the end of 2022 and into 2023 that several companies got national attention because of layoffs. And this happened not only in the various states, but throughout the entire country. On May 1, FedEx announced that it will close 29 locations later this year, and it's going to initiate another round of furloughs in May. This will be the third round of furloughs that they've had in the last 6 months. Then Amazon, between November and January of 2023, laid off 180,000 employees. And in March, the company announced that it's going to lay off another 9,000 employees. Google laid off 12,000 employees in January, and some of you may have seen articles about that. They got some criticism because they sent the communication via email. Not that that is a bad thing to do necessarily, but Google is known as being very proactive and pro-employee, and the employees did not appreciate getting an email to notify them that they were being laid off. I want to talk a little bit before we get into the details of voluntary and involuntary reductions in force. One thing to be sure that you do, if it looks like you are going to need to reduce your workforce, is to consider all options that are available before you get to that point. Could you do a hiring freeze? Could you reduce either the hours of your employees or the schedule for your existing employees, which could prevent you from having to lay off employees? Could you reduce pay for existing employees? Most companies, when you're looking at this, it's for business needs and financial concerns to try to cut your overhead costs. And then if those practices don't work, furloughs would be an option. We'll talk a little bit about those. And as a last resort, a reduction in force. One thing I want to mention about reducing hours and pay is to make sure that you are considering the requirements of the Fair Labor Standards Act and any wage issues that may exist. So for example, if you are going to reduce the hours and the pay of exempt employees, you need to make sure for an exempt employee, for example, that you pay them during any work week in which work is performed. There's some very limited exceptions to these rules, but for example, for a salary reduction for an exempt employee, you've got to be very careful because making a deduction that's not within the specific exceptions can result in the loss of their exempt status. And the courts have determined that, for example, if you make let's say that you know you need to reduce your overhead and you're going to make a predetermined salary reduction because of business and economic needs, a slowdown, for example, then your change is bona fide and it's not in any way to avoid paying the salary required for an exempt employee of the FLSA, under the FLSA, you can do that. You can, and the key there is scheduling it ahead of time and saying, during this time period, we are going to be reducing the salary of all exempt employees or exempt employees in a particular department. If, on the other hand, you kind of go at it on a week to week or a month to month basis, and you just say, we're going to see how it goes. And if we need to reduce pay one week, we will, and we might not have to the next week. That is not allowed. That could very well result in a loss of the exempt status. Regardless, whatever you do with an exempt employee, the pay cannot go below the salary basis, which is $684 per week or $35,568 annually. With regard to non-exempt employees, just keep in mind they have to be paid minimum wage and overtime for every hour worked over 40 in a work week. You can't go below those numbers. And then you also want to be aware that in several states, and South Carolina included, there may be requirements to give notice of any reductions in pay because it's a term of your employment. So the South Carolina Payment of Wages Act would require an employer to give 7 days notice for reductions in pay. If the reduction of hours or reduction of pay is not an option and you want to consider a furlough, that would be kind of the least detrimental thing to your employees, I guess, after those reductions. Furlough is a term that's sometimes misused. During the beginning of the pandemic, you saw a lot of furloughs, and sometimes employers were referring to furloughs as a total layoff, and other times as a temporary leave. It is a mandatory temporary leave. It is where you say to the employee, you are going to have a leave of absence for this time period, whatever it may be. We anticipate that we will bring you back. It's often used as a way to try to reduce overhead during a downturn in business. You can either do it with a block of days or months, or you can do it with a reduction in the number of days worked over a certain period of time. So you might, for example, say all salesmen are going to be furloughed during the month of July, and it works that way. Generally, employees remain on the payroll and benefits continued. Under different state laws, your employees may be entitled to partial unemployment benefits because their days worked and hours are being reduced. The next type of reduction that you might want to consider would be a voluntary reduction in force before you get to the point where you're doing a mandatory reduction in force. And for all of these, you'll see, because there's so many things to consider, this is why it's so important that you look ahead, you try to plan ahead and prepare for this, that it's not a rash, last-minute decision that you're making to cut employees the next week. You're thinking about it, you're documenting it, and you're doing the way that it needs to be done to be in compliance with the laws. So for a voluntary reduction in force, this would include some type of offer. It might be, for example, an early retirement incentive for an employee to voluntarily separate employment. The key here is it's voluntary. The employee could tell you, thank you, but I'm not interested. It's generally conditioned on an employee signing a release of all claims. In other words, for this benefit that I'm getting, I am now going to release the company for any and all claims. It has to be supported by consideration to the employee. We'll talk some about that later too. The consideration is something of value that is not already owed to the employee. And you got to make sure that you aren't acting in a discriminatory manner when you select the individuals who will have the opportunity for the voluntary reduction in force. For reductions in force, collective bargaining agreements, if you have union employees, it may not apply here. We'll talk about those some later, but for a collective bargaining agreement, because this is voluntary, you may not have an issue with the terms of that agreement preventing you from doing what you want to do. So early retirement incentive packages, you see this a lot as a voluntary reduction in force. Again, has to be voluntary. It's offered to a group of employees, and you don't want to discriminate or create a disparate impact against a protected class when you're offering the early retirement incentive package. It's going to be open for a reasonable period of time during which anyone can opt in and choose to take the retirement benefit. And it cannot result in any type of arbitrary age discrimination. A lot of times you see early retirement incentive packages based on seniority, primarily because if you're really wanting to cut some overhead, the more senior employees are generally paid more, so you're saving more. But it cannot be an arbitrary discrimination against everybody who's over a certain age. And as most of you, I think, probably know, the Age Discrimination and Employment Act protects individuals who are 40 or older. Let's talk about the Older Workers Benefit Protection Act. This is actually an amendment to the ADEA that took place in 1990. And what it does is it makes it unlawful for employers to target older workers when laying off part of their workforce or reducing their staff. You can't target older workers. You have to make sure that you follow procedures when you ask anyone who falls within that protected class for an age discrimination claim, which is 40 or older, to waive, when you're asking them to waive their rights or to release the company from any age discrimination claims, you have to follow certain procedures or that release is going to be invalid. And you cannot use the employee's age as a basis for discriminating against them with regard to benefits. Now, one thing that is that the Older Worker Benefit Protection Act says, and I've got this on the second part of the slide, it is not unlawful for an employer to observe the terms of a bona fide employee benefit plan, because the early retirement is a benefit that is voluntary early retirement incentive consistent with the purposes of the ADA, which is another way of saying that is not purposefully discriminating against older employees. So it's saying, yes, you can have an early retirement plan, and that will not run afoul of the Older Workers Benefit Protection Act, and it's not age discrimination, but you have to do it. It has to be bona fide, and it has to be where it is not something focused on age, trying to get rid of the older population. So an involuntary RIF, let's talk about that. Involuntary is obviously, like it says, it's not voluntary. You are laying off a workforce, part of your workforce. When you go through the process of trying to determine how are we going to implement an involuntary reduction in force, you want to consider and document what the legitimate business needs are. What is the reason for it? Is it overall financial issues? Is it lack of a production or work in a particular department? Is it lack of work for employees who hold a particular position across the company? And then what is the goal of it? Are you trying to just reduce overhead? Are you trying to reduce workers in a certain department because of the lack of work? Same thing with trying to reduce certain positions across the board. The most important thing that you're going to need to spend some time on it is the selection criteria. How do you choose those individuals who are going to be selected for the reduction in force? There's different things you can look at. Seniority is one. You might have heard last in, first out. So in other words, the least senior person is going to be the one who leaves. Performance, and we'll talk a little bit about that in a minute, but that's something that companies sometimes look at. And it can be more than one factor. It can be a combination of factors, but it cannot be discriminatory against any protected class. And it needs to be based on some objective factors to the extent that it can be, like seniority, or we've got to reduce this number of individuals in this department. We're going to now cut all sales associates or senior sales managers or production workers in this department. You want to consider all the federal discrimination laws. You also want to consider any state laws that might apply. These are the federal laws that I've just referenced. So Title VII, race, gender, gender identity, sexual orientation, pregnancy, color, national origin, religion. Obviously the ADEA, 40 and older. The Americans with Disabilities Act, someone who has a mental or physical disability. The Uniform Services Employment and Reemployment Rights Act, which is USERRA, that protects veterans. And then GINA protects and prevents discrimination against individuals based on genetic information. So when you are selecting employees and you go through your selection criteria, where sometimes you end up with a complaint or a lawsuit, or you run afoul of the law, is if your employees who are selected, this somehow discriminates against employees in a particular class. Keep in mind that these federal discrimination laws are very broad. They also prohibit retaliation, and they protect certain activity. So you might want to look at and think of recent complaints and protected employees, activity that employees have engaged in. For example, filing an EEOC charge is protected activity under Title VII. So if you are laying off 10 employees and it just so happens that 5 have filed EEOC charges, which hopefully you don't have, but that may be a problem. The Fair Labor Standards Act prohibits discharging an employee because the employee has instituted any proceedings related to the FLSA. So with that, it's like somebody made a complaint maybe with the Department of Labor. You need to think about those things and whether those employees are being affected by reduction in force. You want to consider state discrimination laws too. For example, South Carolina prohibits retaliation against an employee for instituting a workers' compensation proceeding. If you have 7 employees and 6 of them have filed workers' comp proceedings and they're all being terminated through a reduction in force, it's going to look like you're targeting those employees who have filed workers' comp claims. Consider employees on protected leave. You could have employees who are out on the family medical leave, under family medical leave. You could have employees who are disabled under the Americans with Disabilities Act. And we mentioned earlier, protected, you could have employees on military leave under USERRA. I want to talk just a minute about layoffs and collective bargaining agreements, because if you do have a collective bargaining agreement, you need to review it and make sure the terms are being followed. If you have a voluntary, mentioned earlier, voluntary, your collective bargaining agreement may not address it. If it's involuntary, it probably is addressed. They generally have requirements related to the selection criteria. They sometimes have bumping rights where they allow you to bump a worker with less seniority. There are things, super seniority, which is basically going to protect a union representative or a shop steward from being included in the layoff. And then recall rights, because if you're in a situation where you plan to recall employees, they may give priority, the CBA may give priority to certain employees being recalled. Give you some general tips for conducting a RIF. I mentioned earlier, set it up well in advance, identify what you need to do, determine whether the WARN Act applies, which Mary Stewart's going to talk about, consult with legal counsel, document your legitimate business reasons for the RIF, also the decision on how you decided which business unit, department, or positions were going to be affected, and then of course the selection criteria. Use the objective criteria whenever you can. If you use performance as part of the criteria for selecting the individuals, I would only have that be a portion of it. We have seen several cases where someone is terminated, included in a reduction in force, and it's based on the performance. That's how, the employees with the lowest performance scores were terminated. And the employee is claiming race discrimination or gender discrimination. And what they say basically is, well, I had a low performance score because my manager is discriminating against me. So of course so it kind of works its way into a discrimination claim. What I always recommend is that you review the demographics of your workforce. You look at all of the protected classes in your workforce prior to the reduction in force. And then before you implement it, you do a snapshot of how it's going to look after the reduction in force. And you see whether there's any issues there. Are there situations where you are terminating a lot of individuals who fall within a protected class, or there's some concern that there could be discrimination? And then you make adjustments to your selection criteria as needed. I've actually seen situations where someone has done this and then come back and decided to revamp the way they were going to select the individuals for the reduction in force. In the last few minutes that I have, I want to talk about severance agreements, because you're going to have a severance agreement, certainly if it's a voluntary layoff, but a lot of the times you're working in some benefit to the employee so that you can get in a severance agreement a release of all claims. The EEOC considers a severance agreement basically to be any contract with an employee that specifies termination, layoff, and generally has some type of benefit going to the employee in return for a release. Sometimes they're called separation agreements, termination agreements. Sometimes they're called covenant not to sue. If you haven't looked at it, the EEOC has a document called Q&A, Understanding Waivers of Discrimination Claims and Employee Severance Agreements. And what it talks about is not only what needs to be in a release for any discrimination claim, but specifically what needs to be in a release under the Older Worker Benefit Protection Act for the release of an age claim. So general requirements for waivers of just discrimination claims, any discrimination claim, needs to be supported by consideration. You've got to be giving the employee something. The waiver needs to be knowing and voluntary. So the employee needs to know that they are waiving their right to ever file a lawsuit against the company. It cannot require an employee to waive rights beyond the date the agreement is signed, and that's important. You can't say you're going to waive all rights or all claims against the employee up through the date of this agreement and continuing forever after. That makes it invalid. You cannot require an employee to waive the right to file a charge with the EEOC or to participate or testify in an investigation or hearing or any other proceeding conducted by the EEOC. So you want to be aware of that. You could have a situation where the employee who is being terminated and who is signing the release actually has a pending EEOC charge. If that's the case, you can ask the employee to withdraw the charge, which the employee may do. But keep in mind that the ultimate decision as to whether that EEOC charge goes away is going to be in the hands of the EEOC. So you can't control that, and you can't have the employee promise that the charge will no longer be there or that they're going to release you from making the charge. Consideration for the severance agreement, when we're talking about something of value that's not already owed, just keep in mind it can't be if you owe accrued and unused vacation at the end of employment. And in South Carolina, that means if you don't have a notice specifically saying to the employee that the employee is not entitled to any accrued and unused vacation, then the employee gets the money that represents that accrued and unused vacation. That's considered wages under the South Carolina Payment of Wages Act. So if you do owe it, that's not going to be consideration for the release. You can't make a bonus that you owe to the employee be consideration. Sometimes you certainly can have a lump sum payment not already owed, and then there may be a situation, depending on the circumstances, where allowing the employee the right to resign could be part of the consideration that you give in return for the release. Where you've got a valid reason for termination, you've got documentation, they're going to be terminated, and that right to resign is of value to them. Or you could include that you will not contest unemployment. Just be careful there, because if you are completing information and submitting it to your state unemployment commission, in South Carolina, be Department of Employment Workforce, you've got to be truthful, and you want to be truthful in what you're saying in that documentation. What is the definition of knowing and voluntary for an age discrimination claim to be released? It has to be written in a manner that is clearly understood. You've got to use plain language geared toward the education and the general comprehension level of the employees you're dealing with. You can't have it be misleading. And the EEOC gives some examples. You have to be careful. You'll end up putting too much legalese in a document and the employee won't have a clue what's going on. You must specifically refer to rights or claims arising under the ADEA by name. And what I generally recommend is that you reference all federal employment statutes, because there's other statutes like Title 27 that require you to specifically reference the statute in a release. You have to advise the employee in writing to consult with an attorney before accepting the agreement. There was a case in which the The release or the severance agreement said that the employee acknowledged that they had had the opportunity to consult with an attorney. And the court came back and said, no, you have to tell the employee you have the right to consult with an attorney. So that's important. You have to provide 21 days to consider, for the employee to consider the offer. That employee doesn't have to take that. They could take 1 day and turn around, but you've got to offer the 21 days. You have to give the employee 7 days to revoke the agreement, and that cannot be adjusted. The employee could sign it and bring it back early, but that 7 days is going to run from the effective date, from the date that it's signed. Can't include a release that arises after the date of the waiver, the date of execution, has to be supported by consideration. So these are the 7 factors that you have to have for an age discrimination claim to be knowing and voluntary. This language is going to need to be in the severance agreement or release that you have with anyone who is 40 or older. You want some of this language to be in an agreement for any employee, because again, discrimination claims in general, in order to release them, it has to be knowing and voluntary. But the other agreements with someone under 40 do not have to have the reference to the 21 days or the 7 days. If it doesn't meet the knowing and voluntary, or if it's induced by fraud or undue influence to try to get an employee to sign a document, a release, it is not going to be valid. Group layoff, let's talk about that a minute, because what I just gave you would refer to when you're dealing with somebody 40 or older, where you are laying off one employee. If you're laying off a group of employees, there's additional requirements. And the way that the group is defined is basically 2 or more employees. So we're not talking about 100 like we might be with the Warren Act. This is 2 or more. The EEOC considers a group layoff to include a voluntary exit incentive program or any other employment termination program. So if you have 2 or 3 employees who are in a particular department or in your company, and you're going to be laying them off to reduce the workforce, you're going to need to comply with this. You're falling within the group layoff. So basically, EEOC says this exists if you offer additional consideration incentive to leave in exchange for signing a release to more than 1 employee. So here's the additional requirements for the group layoff. You would have, the employee has up to 45 days instead of 21 days to consider the waiver. They still have the 7 days to revoke. And then you have to inform the employee in writing of some additional information. You've got to tell them the unit, the class, or the group from which the employees were chosen, who was selected and who was not selected. So that could be, if you're reducing your workforce across the company, then the entire company is the decisional unit. If it's a particular department, then it's that department. Eligibility factors. How are you making the decision? Is it everyone who works in this particular position? Is it everyone in this department? Applicable time limits. What's the time limit of the layoff? And sometimes you might have where you're going to do a reduction in force on one day, and then 2 weeks later you're going to do another one, or 1 month later you're going to do another one, and the time period would expand the entire time period. Job titles and ages of all employees who were eligible or selected, and then those ages of the individuals in the same job classification who were not selected. So I'm going to give you an example. This example actually is given by the EEOC. So in your document, you would be telling the employee the time period and the decisional unit, whether it's the entire company or particular department from which these employees are selected. And then you're saying, here, you don't give employees names, but here's the positions, here's the ages of each of those positions, the numbers of employees who were selected, and then the number of employees who were not selected. So you can see, for example, with bookkeepers, they've selected for the reduction in force 9 individuals, 6 of them are age 45. So they're in the protected class of 45 and older. But this is the information you've got to give to all the employees for a release, a group layoff under the Older Worker Benefit Protection Act. Best practices, and then I'll turn it over to Mary Stewart. So I would include a cover letter. If you're giving someone a severance agreement who is 40 or older, include the cover letter and put the date of the 21 days so they will know the date that they have to return that document up to 21 days. Be aware that if you're making material changes in that document, your 21-day period is starting to run again. If you give them a severance agreement and they ask for revisions, or you decide you're going to make revisions, the 21 days restarts. For employees who are under 40, I would do the same thing. I mean, in the sense that I would give a cover letter that tells them when to return it, because this offer is not typically open-ended forever. So I would say you have until, Friday, May 13th or whatever, to return the signed agreement. You don't have to give them any particular time period, but you'd want to give them a reasonable time period to review it. Specifically reference the federal employment laws in this agreement. When you have the release, spell those out so that the employee will know they're releasing all claims under that. Make sure the severance agreement is not signed before the last day of employment, because it's not going to recover anything after it's signed. So if you have an employee who's leaving in 2 weeks, you give them the severance agreement, they have 21 days to review it, they return it in 2 days. 2 days. They've now signed it just under 2 weeks before they leave. They leave 2 weeks later, and they can sue for discrimination because they were terminated, because the release has not covered the last 2 weeks of their employment. One way to handle this, and how I do it, it gets a little bit complicated, but is to, in a situation like that, have an exhibit that is a release that they sign on their last day of employment. You need to be aware of what you're doing, because if you're saying to the employee in this situation, we're going to keep you on for 2 more weeks, and you will be terminated on this date, and in return, you're going to sign this agreement now for the benefit that you're getting, the lump sum payment, whatever it is, and you're going to sign this release on your last day of employment, which will work, but you have in effect modified your at-will relationship with that employee. So you need to be aware of that. Make sure you make the deadline for paying severance after the 7-day revocation period for anyone in the age protected class. Otherwise, if you pay severance on the 6th day and they revoke on the 7th day, you're going to be out your money. I mean, you could sue them for it, but that's a lot of trouble. So, and you just want to make sure you have followed all of the knowing and voluntary requirements under the Older Worker Benefit Protection Act. And with that, I am going to turn it over to Mary Stewart so that she can talk about the Worker Adjustment and Retraining Notification Act, which is known as WARN.
Great. Like Sherry said, I'm Mary Stewart King. I'm an associate, and we're going to talk a little bit about WARN. It is a fairly complicated act, I will say, especially given the fact that we have state laws now popping up that interact with the federal one, and sometimes making those requirements a little bit more complicated for employers. But first, we're going to talk about the federal law. And it became effective in 1989, and it was really born out of steel mill closures, particularly, I'd say, Pittsburgh and Youngstown. But this was a way to require covered employers, which we'll discuss what a covered employer is, but to provide 60 days notice to employees to kind of protect those communities and give notice to that employee so that they could find another job. And it also requires notice to local and state level government entities, as well as a representative of the employee if they are unionized. So to be an employer that is covered under the WARN Act, essentially these are going to be private employers or a public entity that is operating in a commercial context. So we're not going to have any federal government or other state agencies that provide public services that would fall under this. So we really then have employers that are in the commercial context, private, that have 100 or more employees. And these are only going to include full-time employees instead of part-time. As for the employee coverage, it's going to apply to hourly and salaried workers, as well as managerial, supervisory. And part-time too. So although part-time employees are not counted in getting to the 100 employees to be a covered employer, they are still going to be entitled to notice. So there's two major scenarios that are going to trigger notice under the WARN Act if you're a covered employer. That's plant closing and a mass layoff. So for a plant closing, it's where an employment site is going to be shut down, and that's going to result in an employment loss, which we're going to discuss a little bit later, for 50 or more employees during any 30-day period. In the mass layoff scenario, there are kind of like two conditions that could be met. First, if you lay off 500 or more employees at a single employment site during a 30-day period, that's going to qualify as a mass layoff. Or if you're laying off between 50 and 499 employees at a single employment site, and that makes up 33% of the workforce. So for example, if you had a total of 150 employees and 50 are laid off, that is going to qualify for a WARN Act notice. So with the rise of remote workers, I wanted to touch on this a little bit about mass layoffs, because mass layoffs are applying to a single site of employment. And that's not defined in the Act, but the regulations say that it's either a single location or a group of contiguous locations. So the regulations are also then providing that a mobile worker, for example, a salesperson whose primary duties are to travel around, but they have a single point of employment, and they call that single point of employment, it's going to be their home base. It's going to be where they get their work from, or where they're going to report to a supervisor. And the big deal about this is you're going to want to consider all of your remote workers and where their home base is when you're determining whether you are having a mass layoff, because those employees are going to count in those numbers. Recently, or a few years ago, this was a class action against General Dynamic, and it was a class of solely remote workers. They were suing under the WARN Act that they did not receive notice. These employees were not salespeople. They were actually employees who worked on a hybrid work from home schedule under a policy that was actually called the flexible work location policy. So something that we see a lot nowadays post pandemic. This is something that was addressed then, and the court certified this class action, allowing it to go forward. So although that is not saying immediately that all remote workers are going to be able to join at one site and file a class action and that be able to move forward, but this is a step in the direction of making the WARN Act more prevalent. So there are three scenarios where the WARN Act is just simply not triggered. They might seem like a mass layoff or a plant closing, but these are in a different category. So it's where there's a temporary facility that you knew it was going to be temporary and that closes. Where you have union activity and there's a strike or a lockout. And lastly, where there's a particular project or facility that was meant to be temporary for that certain project, and the employees were hired understanding that their employment was limited to that project. So going back to employment loss under the Act. So for example, when we say that a plant closing, if you have 50 employees that experience an employment loss in any 30-day period, what is an employment loss? So we have three scenarios that qualify: your basic termination, where a layoff exceeds 6 months, or where during a 6-month period that an employee's hours are reduced by more than 50% in any given month during that 6-month period. Now, there's a really narrow exception. It's called the business relocation transfer exception. And this is when essentially termination or transfer or some kind of layoff is not going to be considered an employment loss for your numbers. So it's going to apply only if the closing or the layoff results from the relocation or consolidation of the business. And in that case, it's where an employee refuses to transfer to a different site where that different site is within a reasonable commuting distance. Or if an employee accepts the transfer, even though it's not a reasonable distance for his commute, as long as they accept this offer within 30 days after it's been offered, this offer to transfer, or they accept it within 30 days after the occurrence of the closing or the layoff, whichever one of those is later. So in both cases, though, the transfer offer has to be made before the mass layoff or the closing occurs. There can't be more than a 6-month break between when the employee was at one location to the next, and the new job can't be considered a constructive discharge, meaning that you can't be offering this to an employee simply because they're probably going to quit themselves voluntarily. So a quick example when we're looking at what an employment loss is. So if we have a covered employer, they are expecting just a 2 to 3 month long temporary layoff. So much like a furlough, like Sherry discussed, it's got at a single site and they're laying off 500 full-time employees. Is it going to be triggered? In this case, no, because this is not an employment loss. So it's not falling within termination, a layoff that's more than 6 months, or a reduction in hours of more than 50% for more than 6 months. We also have the 90-day aggregation rule. I know this is a lot of math I'm throwing at you. So here is where an employer will really want to look forwards and backwards in terms of when they are expecting predicted employment losses to occur. And so the really big deal about this is if the aggregated employment losses trigger the WARN Act, meaning you have enough that occurred in the past 90 days and enough that you expect to occur, the notice requirements are actually going to begin at the very day of the very first individual termination. So you're going to be going backwards in time, and you don't want to be playing catch up on this 60-day notice requirement. So there's only really one way that an employer, is not required to give notice where we have these 90-day aggregation of layoffs. And it's not going to be required where the employer is demonstrating that the employment losses are from very different causes. And it's not an attempt to evade the WARN Act, because this 90-day aggregation rule, the whole point is to prevent employers from using repeated small layoffs to escape these notice requirements. So quickly, we've discussed this before, but it is a 60-day notification period for employees as well as to the two government entities that the employer must provide notice. And keeping in mind, if these separations are occurring kind of spread out as opposed to all at once, just making sure that these notices are issued 60 days prior to that individual employee's separation. So in these cases, this is not so much where the WARN Act does not apply. It is just where the WARN Act applies, but you are allowed, is what I'll say, to give less than 60 days. But your employer should give as much notice as practical and under these circumstances. So the first one, which is super narrow, is the faltering company exception. It's only going to apply to plant closings, and it's where a company is seeking out new capital to stay in business, to keep all their employees. And if they give that notice, they might lose that opportunity to keep all their employees and get that new capital. Then the second one is unforeseeable business circumstances, which is where at the time that notice was required to be given, the employer did not have reasonable, notice of what might be happening. And this is because it has to be a circumstance that is sudden, dramatic, totally out of the control of the employer. For example, this could be where an employer loses a really big client, or it could be where there's a really dramatic economic downturn. So something that's out of the employer's power, essentially. And this is going to apply to both plant closings and mass layoffs. And lastly, the most obvious example of an exception to the 60-day notice is if a hurricane, flood, earthquake, something comes through, the employment site, and operations have to be shut down. In that case, 60 days notice is not required, just as much notice as possible. So here we have another example, and this is with the same covered employers. So they are expecting, again, that 2 to 3 long temporary layoff. They're still laying off 500 full-time employees. But at the 3-month mark, some unforeseen business circumstances arise that are out of their control, and they believe they're going to have to extend the layoff beyond 6 months. So this is when you get into the scenario, which could be very common now in this economic environment, is a touch and go of how much longer are we going to have to extend this or not, and are we going to be able to stay in business? And so when was the WARN Act triggered? In this circumstance, it was at 3 months, because this is the unforeseen business circumstances exception that we talked about. They couldn't have, or because it was unforeseen, they couldn't have known at the time that the layoff occurred, or to give 60 days notice prior to that. But a layoff that extends beyond 6 months for any other reason is going to be treated as an employment loss from the date the layoff starts. For example, if this employer actually did know that the layoff was going to last longer than 6 months, but they just didn't announce it, it's going to be triggered from the very beginning, and it could result in WARN Act violations for that employer. So one of probably the most important parts, aside from the 60-day deadline, is what exactly needs to be included in this notice. So this is going to be things that need to be included that goes to the local and state government, as well as the employee or his or her union representative. And the most important thing is that this notice has to be written. It can't be given over the phone. It can't be given, at a meeting. So this has to be written. And typically for the employees, the best way to do that is personal delivery, handing it to them directly, or giving it to them in a paycheck if they receive their check in an envelope, weekly, bi-weekly, providing that notice to them in their paycheck. And then you could also do this by first-class mail. As for the government entities, simply a fax or an email will do, but then you're encouraged to follow up with mail via overnight or certified to ensure delivery. As for the contents, this is pretty basic of the who, what, when, where that we would expect. And, it has to be very specific, but the language has to be plain so that a layman can understand this. Like Sherry kind of discussed earlier, we don't want something that has a lot of legalese, so that we want to make sure that this notice is clear so that it can be valid under the WARN Act. So first, we want to make sure we know whether this is a temporary or permanent layoff for that certain employee. So should they expect to be recalled maybe after 6 months, or is this going to be the end of the road? Whether part of the plant is closing or the entire plant, so maybe just the department. And then essentially when these layoffs are going to start, as well as the specific employment loss date for that specific individual. Sherry also discussed bumping rights a little bit, which are essentially seniority rights, and they're typical in union settings when you have a collective bargaining agreement. So in this case, if we had a senior employee who had been there for more than 15 years, and then a new employee that had been there for 1 year. And if under the collective bargaining agreement, there's a seniority provision, that is essentially going to be that even though the more senior employee's position was being eliminated, he will get to take that newer employee's position, and that newer employee will be the one who experiences the employment loss. And lastly, you'll want to provide just a point of contact for the employee should they have any questions. So in the event that an employer runs into a violation of the act, which is, like I said, this is super complicated. So it's not impossible. And so here we have, for employees, this is less a penalty and more of a recoverable damage that these employees, if they experienced, if they're a aggrieved employee, they would be able to get back pay and benefits for the period of the violation. So the period of the violation means at the time of which the notice was not given. So and that could be up to the full 60-day notice period, depending on the violation. As well as we have the unit of the local government. Those are civil penalties, which could be up to $500 per day of violation. So each day that the notice is late will be a $500 fine to the employer. So these are actually in, like I said, in this economic environment right now that we have, these are very common. Sherry went over, Amazon and Google and other companies that are experiencing RIFs. But here we have two really, really recent class action lawsuits. And on April 4th of 2023, we have a class action that was filed against Virgin Orbit. And the employees are alleging that they didn't receive advance notice. So to give you an idea about this company in this case, Virgin Orbit is a really unique company in a way that they're using airplanes and attaching a rocket to them when they are trying to send a satellite into space, as opposed to sending the rocket straight from the ground. So here we have Virgin Orbit. In late March, they tell their employees, look, we're laying off 85% of our workforce. And it was not within the requisite window. And they're saying that they wanted to do that to reduce expenses in light of the company's inability to secure meaningful funding. So this is an interesting example of, or what might be an interesting example of, the unforeseen business circumstance. As it was in January that they had some malfunctions with the rocket and it didn't make it, and then they were losing some of their stock value and funding. So whether or not, having a company of this nature, whether or not that's foreseeable that they would not make it to space and lose funds is going to be interesting. And then next, Jenny Craig, this was just last week. The employees are filing a class action, also alleging that they were not given advance written notice. And this one started as a layoff, and now it has become a full company closure, which means that even more employees are impacted. So in the couple minutes that we have left, many WARN acts, which are state level acts, are becoming even more common. So you can see here in dark blue are the states that have a mini WARN act that employers in that state, or employers that have employees operating in that state, will need to also comply with. As you can see, there's not many in the Southeast. We have Tennessee, but employers that span across, the whole United States should be aware of these. And so we're going to discuss three of the states really quickly with the stricter requirements. That's California, New Jersey, and New York. So just to give you an idea, California, as opposed to the 100 employee requirement to be a covered employer, California, as you can see, only requires you to have 75 employees. and they're going to include part-time employees in that count, whereas under the Federal WARN Act, only full-time employees are counted. The notice period is the same, but where there's a plant closure, it's not going to be the more than 50 employees. It's going to be any amount of employees. So anytime a plant closes, it doesn't matter how many employees are there, that's going to trigger this mini WARN Act. Then lastly, normally with a layoff, it would be if it's 50 or more employees up to 500 under the federal law, we have to have it be 1/3 of the workforce. Here, they're only saying that it's 50 employees no matter what. So in New York, this is similar to California. They are requiring, stricter notice periods, and then the fact that it's applying to more employers, because it's going to apply to more smaller businesses. So this is going to impact a lot more employers than the Federal WARN Act. So for New York, they'll cover as few as 50 employees, whereas traditionally federal is 100. The notice period has been extended from 60 days to 90 days. And then a plant closing is when an employment loss affects 25 or more full-time employees, where usually it's 50 under the federal law, whereas a mass layoff is going to occur when there's at least 25 full-time employees who are 1/3 of all of the work site, or at least 250 full-time employees. So going back to the federal act, again, the difference there is, we've dropped from 50 full-time employees who represent 1/3 to 25. And then instead of 500 full-time employees, we have 250. And lastly, this one is not only fairly new, like a month old, but it's really, really unique in the way of the last bullet point. So these other ones, covering employers with 100 or more, it's going to include the part-time employees instead of just full-time. They are going to start aggregating places of employment. So when we're looking at the single place of employment for the mass layoff, that could actually include several locations throughout the state. And then the notice period has been extended by 30 days. And the mass layoff, it doesn't have to be 1/3 of the workforce. It's just 50 employees no matter what. But the most interesting part of this, and probably the biggest impact this is going to have on New Jersey employers, is that New Jersey employers are going to have to provide affected employees with a severance pay that's equivalent to 1 week of pay for every year that they were employed. And that's regardless of whether or not they comply with the Mini WARN Act of New Jersey. So no matter what, if an employee was employed for 7 years and they are experiencing the employment loss, they will be entitled to 7 full weeks of severance pay no matter what. Then, if the employer ends up failing to give the requisite 90-day notice, in addition to that mandatory severance payment, employers are also going to have to pay an additional 4 weeks of severance pay, sort of as a penalty violation type deal. So this is only one of its kind. It's brand new, but it is enforcing much more. It's going a lot broader than any other state and the federal laws in terms of just stepping outside the bounds of notice, but more looking at providing severance. I think we have a question really quick. I know we're almost out of time, and that was my last slide, but the question is, for New Jersey, the mandatory severance amount can remain contingent on signing an acceptable release, correct? So unfortunately, no. So I guess I'll say yes and no. So if the employee is in the state of New Jersey, they are already entitled to this severance payment no matter what, 1 week for every year of employment. So if you wanted to make it contingent upon a release, what you would do is give them 1 extra week. And then that would provide the consideration to make that binding. But unfortunately, it would have to go above and beyond what is already required by this very, very broad law. And I'm going to let Sherry pop back on. And if anyone else has any other questions,
Thanks,
so
Mary Stewart. We did have a question to show slide 36 again.
okay.
And you may have, I think you're able to do that.
Yeah, I apologize. Yeah, so Michael, I just saw the rest of your question. So he says, right, but if I offer 1 extra week to this New Jersey employee and they refuse that, they're still entitled to the other 7 weeks because they were employed for 7 years. The answer is yes, but they're not entitled to that 1 extra week. They're only entitled to what they were already entitled to under the law.
All right, thanks, everyone. If anybody has any other questions, after we sign off, feel free to contact either me or Mary Stewart. And we appreciate everyone attending. Have a great day.
Thanks.